As I said, this case is not about the creation of OSHA, but of the powers Congress delegated to it. The Constitution vests all legislative power herein granted in a Congress of the United States, Article 1, Section 1 of the Constitution. And we have held that the Constitution categorically forbids Congress to delegate its legislative power to any other body, including to an administrative agency. All legislative power, all power to make law, is vested solely in Congress, and the Constitution does not delegate that body the power to delegate the powers vested in it. However, the courts don't seem to get tripped up on this particular detail. But under our precedent, a delegation of authority is constitutional so long as a relevant statute sets out an intelligible principle to guide the agency's exercise of authority. If, as the court has held, the Constitution categorically forbids Congress to delegate its legislative power to another body, how can they say that the delegation of authority is constitutional under any circumstance? The answer is by violating their oath of office and placing precedent and politics above the supreme law of the land. The Court of Appeals for the Sixth Circuit upheld the delegation of authority to the Occupational Safety and Health Administration under this intelligible principle test over Judge Nalbandian's dissent. Based on this unconstitutional intelligible principle test, the courts, including the Sixth Circuit Court of Appeals, have set aside the Constitution in support of a political agenda, namely empowering unelected bureaucrats to effectively make law. Since these unconstitutional laws include the collection of fines, fees, and other pseudo-taxes, Congress's dereliction of duty is the very definition of taxation without representation, or as the Declaration of Independence put it, for imposing taxes on us without our consent. The American people's consent, as shown in the Constitution, did not include allowing unelected bureaucrats to impose fees, fines, or any other form of taxation. Since the courts are not delegated the power to simply make up the rules as they go along, Justice Thomas states, "I continue to adhere to my view that the intelligible principle test does not adequately enforce the Constitution's allocation of legislative power." Justice Thomas is correct. Since the Constitution categorically prohibits Congress from delegating their legislative power to another branch, these laws are unconstitutional and void.